Uh, by reading blood GOMS number 29.
Yes.
Blood, your lordship may kindly see page number, just recapitulate your lordship's memory.
Page number?
Page 51 to 52. Para 2. This I have already.
Sorry, page number 52.
51 blood GOMS 29.
Yes.
Dated 8/2/2024. Let the reason blood para 2 your lordship may kindly see.
Yes.
Kindly see. The Secretary Telangana State Public Service Commission Hyderabad wide letter dated 3rd and 4th read above has proposed certain amendments in para B of pattern of examination under the scheme of the examination for Group 1 services prescribed in the government order first read above, and in the light of certain court cases filed in this regard and observations of the Honorable Supreme Court in Public Service of AP Public Service Commission versus Baloji, Badawat versus so and so. Let the government after careful examination so and so, so and so. But the reason given is that because of certain court cases are pending, therefore such a reason is not, I said that violates of Article 14 and 16. Then Lord, your lordship may kindly see. The counter filed by the Service Commission in this case, blood in the other case, blood not in this case. My cases are filed only yesterday, blood. The other case where my senior colleague, Mr. Madan Mohan, argued, blood.
That is public service
commission filed.
They expanded out by learned senior.
Yes, they expanded the scope. Blood, your lordship knows. Supreme Court judgment, Honorable Supreme Court judgment, Mohinder Singh Gill case. Not what is stated in the impugned order we have to see. Not when it comes to challenge before the Honorable Court. Not it is expanded or not. I'm sorry, blood. Explain blood rather than expanding the scope, blood, which is contrary to the reasons stated in the GOMS 29. Blood, I'm sorry.
Yes.
Let the Honorable Supreme Court held that blood, such a blood, this thing is bad. So therefore, blood 1978 1 blood Supreme Court blood 405 blood judgment of the Honorable Supreme Court blood in Mohinder Singh Gill case blood para 8 blood their lordship said that blood when it comes to the challenge before the Honorable Court blood a particular blood impugned order or particular amendment to the rules blood they cannot blood expand the scope of the blood what is stated in the order has to be judged, but not the explanation or blood other thing supplied or supplemented in the counter affidavit cannot be looked into. That is the sufficient. Then blood the other thing is blood by virtue of GOMS 29, blood the reserve candidates blood being selected, though they got merit blood in the reservation quota only blood. Blood they have specific quota. They are being considered not yes blood, not merit blood. That is my case.
That has been argued by
yes.
Senior Counsel.
Then blood the other thing is blood second point blood my second submission before your lordship is blood the biometric blood was not taken earlier when the second blood supplement preliminary examination results were published. Then that was the subject matter before the Honorable Court, file WP number 15881 of 2023. 15811 of 2023. Let the Honorable Justice Lord Madhavi Devi decided this matter. Blood set aside the preliminary examination and remanded blood to the authorities blood to reconsider the whole issue that
But so far these impugn notifications are concerned, what is the relevance of this one?
no, because that's what the honorable learned judge was specifically page 16 your lordship can you see. Last 6 lines your lordship. There is some relevance in that. That's why I am making it. Otherwise, I will not have.
Yes.
Page 16, bottom 6 lines, you will not come. Therefore, to prevent, your lordship got it, blood?
Yes.
Therefore, to prevent any injustice being caused to them, this court inclined to cancel the group 1 preliminary examination conducted on 11/6/2023 and to direct the respondents to reconduct the preliminary examination by reconduct the preliminary examination. I am stressing this case. Reconducting the preliminary examination by implementing all the general instructions issued in the notification, including the biometric without any exception. Blood notification means notification refers to 4 of 22 blood. So my submission before your lordship is blood for the judgment blood rendered by this honorable court blood by the learned single judge. Blood is binding on the state as well as on the service commission. They have to reconduct. In the meanwhile, what they did is, after this judgment blood, they have introduced blood on 8/2 blood 2024 blood GOMS 29 was brought on 19/2/2022-24 blood a fresh notification was issued. Blood they want to follow blood the GOMS 29. So the judgment is binding blood on the government blood. They cannot bypass it. That is my second submission. Blood my third submission before your lordship is blood GOMS 55 was challenged in WP blood 3048 of 2023. Blood counter affidavit has been filed. In my WP blood repetition, page 229, your lordship may kindly see. Relevant is page 239. Blood para number 27. Blood 28 and 29 blood. Blood entire crux of these three paras is they justified blood 1:50 ratio followed both the stages blood that is preliminary as well as the main examination.
To the same counter on which Reliance was
Yes,
placed
blood.
yesterday.
No, this para has not been read, I think.
Yes.
So, yeah. Blood para 27 blood, you lordship may kindly see. Blood after 4 lines blood, as such 1:50 is the highest ratio for screening in the entire country. Union Public Service Commission picks up 12 to 13 times and most of the state public service commissions follow the ratio. The terms of the notification do not specify any such procedure proposed for the petitioner to lower the cutoff marks. So that means blood 1:10 ratio has to be followed. That is my blood fourth submission. Blood my other submission is blood in the Union Public Service Commission blood both the stages blood preliminary as well as in the mains blood they are following blood rule of reservation, that is blood the ratio which they have blood cutoff marks is fixed blood either 12 or 13 as blood mentioned in the counter blood 1:12 or 1:12 or 1:13 blood they are following. Blood all these blood 4 blood your lordship may kindly see. Blood 4 submissions which I made before your lordship blood clearly demonstrate that the impugned order GOMS 29 was blood absolutely there is no basis for it and blood they want to deprive blood the reservation provided under GOMS 55. They brought this new GO and blood the amendment also no reasons are assigned. Then blood your lordship may kindly see. That I am relying on some blood judgments, blood you not smoke and you see. Eight level,
812, para number?
811 blood.
Yes.
In this connection, it is well to remember that the reservation under Article 16(4) do not operate like a communal reservation. It may well happen that some members belongs to say that scheduled caste gets selected in the open competition field on the basis of their own merit. They will not be counted against the quota reserved for scheduled caste and they will be treated as open competition candidates only. In the instant case also, not if 1:10 is followed in the preliminary examination, which was conducted pursuant to the notification, that the reserved candidates will get more, majority of them, that reserved candidates will get accommodated in the merit, and that some of the reserved candidates will not get accommodated in their own reservation and slots not meant for the The second judgment which I am relaying is Saurav Yadav 2021 4 SCC.
Mr. Counsel, these were all yesterday learned senior counsel relied Saurav
Yes,
Yadav. Saurav
yes,
Yadav, we followed in Madhya Pradesh.
Saurav Yadav, para 60 is I am relaying. He relayed on page 50, 58 he relayed, para 58 he relayed, para 60 I am relaying. So Lordship may kindly note this. Then Dipendra Yadav also yesterday my amendment cited, same judgment we are also relaying. Para number 31 and 32. This you Lordship may kindly. Para 31 the Honorable Supreme Court Dipendra Yadav versus so page number para 31.
Yes.
Page number 11 para number 31. In Saurav Yadav versus so the three-judge bench of this court affirmed that the principle that the candidates belongs to any of the vertical reservation categories would be entitled to be selected in the open category, and if such candidates belong to the reserve categories are entitled to be selected on the basis of so their selection cannot be counted against the quota reserved for them in the categories of vertical reservation. It was further observed that the reservation, both vertical and horizontal, are methods of ensuring the public services, and they are not to receive the rigid slots and where the candidates merits and the otherwise observation also that a general category approaches the bench for the open category is open to all, and not I am testing this now. Open category is open to all, and only candidates for candidates to be shown in its merits, regardless of whether the reservation benefit of either type of was available to them or him or her. This being the this being the settled legal position, it appears that the state of Madhya Pradesh itself realized that the harm that it was doing to the reserved category for doing so, and it chose to restore Rule 4 of its form. So, the enabling drawing of and segregating the reserving of candidates. Then Krishna Chaudhary judgment, your lordship is already is a party to the judgment. The judgment became final. No appeal has been filed, and the state of Madhya Pradesh.
Kishore Chaudhary.
Yes.
Kishore Chaudhary's case.
Yes. So therefore, my submission is another 2006 10 SCC. Kishore Chaudhary, I don't want to repeat it because yesterday my learned friend read all the relevant paras where you want to referred Indra Sahan and other Supreme Court judgments and ultimately that said the amendment made by state of Madhya Pradesh. Therefore, then the other Pitta Naveen Kumar and so on so on. So para 57.
Para 57.
57. I'm reading. That it is from AP only, that and to Supreme Court. The total 558 vacancies were notified, thus only 27,900 candidates could have been called for the main written examination on the basis of the norms fixed by the state itself. However, the actual number of candidates who passed the examination are said to have been 50,726. Although the actual, it is stated that 32,056 candidates appeared. Thus, disputably, a large number of candidates who had been allowed to appear at the examination were virtually permitted to do so in violation of the norms of 1:50, as was specified in the state by the state, and the aforementioned rule could not have been relaxed. That this is the relevant thing. That it did not have any rational basis, and 66% cutoff marks was not fixed by the commission, and it was arrived by the commission in view of the marks secured in respect to candidates and the applying the ratio of 1:50. Once the person falls beyond the ratio, he was not qualified and he was not to be considered any further, and the state and the commission had themselves fixed the three different stages of selection, so on. Blood by virtue of the ratio blood rendered in this judgment by the Honorable Supreme Court, blood obtained blood 1:50 ratio blood, which was followed not only blood in this notification, blood 4 of 22, blood was the first notification. Then this is the second notification which they have issued. Even in previous notification also, blood they have followed the same. Blood that principle has been affirmed by the Honorable Supreme Court, which they have followed blood. The 1:50. That therefore my submission is that we are only requesting your lordship blood 21/10 blood 2024. They issued all tickets blood already to the candidates. They want to come in the written examination. In the meanwhile, we are requesting your lordship blood to stay the blood amendment, and so that blood further blood your lordship can examine the entire main case blood.
Yes.
About the validity of challenging the Rule 22.
Yes, that's all.
Would be but an appropriate.
Yes.
Now let's kindly see what it says. Both my colleagues read it out at the cost of repetition minutes. Government have issued orders regarding classification of post schemes.
170 is scheme of examination.
178 is different.
Come to the second paragraph. The Secretary, Telangana State Public Service Commission, Hyderabad, wide letters, third and fourth read above, has proposed certain amendments to Part B of the pattern of examination under the scheme of the examination for control for Group 1 services prescribed in the government order. Yes. The first issue would be Balaji Badawat is no longer good law if the law was with regards to the classification at the time of the preliminaries.
Which judgment is not a good law?
Balaji Badawat.
Is it overruled?
Yes, not overruled in terms of specifically saying so, but the ratio laid down in Balaji is no longer the good law because the Supreme Court in the judgment that went up from Madhya Pradesh faulted this mechanism that was upheld in Balaji. So the state can't be heard to say that a two-judge bench judgment of the apex court will hold the field and not the three-judge bench judgment, which is the subsequent judgment of the apex court.
Yes.
So the premise on which
This Balaji principle is watered down, we can say, in
Yes.
which matter? In which matter?
Independent. Independent.
It is arising out of Madhya Pradesh High Court.
Yes. So and that is by a bench of three judges. Both on the theory of subsequent judgment prevailing over an earlier judgment and on the quorum strength theory. They could not have relied on Balaji Badawat. Or even assuming that they do, it was incumbent on their part to say there are two kinds of judgments. Our empirical data goes by Balaji, that is why we are doing Balaji. Otherwise, the very issuance of such a GO, the decision-making process largely by a contra view taken by a larger bench subsequently. I will not trouble your lordship with that judgment, my lord, because your lordship, it has been repeatedly brought to your lordship's notice.
What is the exact name of Madhya Pradesh judgment? The first name, it's a batch of petitions.
The subsequent
Which is upheld
judgment.
by Supreme Court.
The subsequent. It is there in my book at page 458 of the paper book. 478 in his book, in the same book. 478 of his book.
The same writ petition.
The same writ petition, sir.
478.
In your writ petition?
No, in
Deependra Yadav.
yes.
That is Deependra Yadav.
Yes.
2024.
2024 6 SCR 36. But what is placed before your lordship is went into exactly the similar question, and your lordship may see that this is two. This is the three.
Balaji judgment is on record. Balaji is on record.
Balaji is not on record. I can pass on the judgment. Where? Give me 2 copies. Ballots, quotas. Yesterday. Manoj, I'll take your lordships to Baloji. Your lordship may kindly come to para 21 of that judgment. Problem with the impugned G.O. is it partly adopts Baloji, partly winks at various other observations made in Baloji. Kindly come to para 21 of that judgment, which I've just passed on.
Yes.
The Appellant Commission, which has been constituted in terms of Article 315 of the Constitution, is bound to conduct examinations for appointment to the services of the state in terms of the rules framed by the state. It is, however, free to evolve procedure for conduct of examination. While conducting the examination in a fair and transparent manner, as also following principles of fair play, it cannot completely shut its eyes to the constitutional requirements of Article 355 of the Constitution, which reads as under. Now, how you deal with Article 355, how you deal with reservations thereof, Indrasani admittedly is the last word as of today. And both of them have showed your lordship that the manner of silting the reservation by the manner in which it is being done would run contra to the ratio of Indrasani. Kindly then come to paragraph 22.
Yes.
How the Commission would judge the merit of a candidate is its function. Unless the procedure adopted by it is held to be arbitrary, against known principles of fair play, superior courts would not interfere with it. Therefore, we labor to show your lordships that the touchstone is it arbitrary? Is it contrary to the known principle? That the alternative is arbitrary is a statement borne out by them in an affidavit. I'll show your lordship what they say in the affidavit at length. Interestingly, I'll show your lordships the nuances of that after I finish this paragraph. The state framed rules in light of the decision of the High Court in Jafar side. Per se, it did not commit any illegality. The correctness of the said decision here and before is not in question having attained finality. The matter, however, would be different if the said rules per se are found to be violative of Article 16 of the Constitution. So even here the division bench says, if you examine it from the point of view Article 16 and find it bad in law merely because it was a rule made in accordance with that law, it will not stand to reason. Notwithstanding the basis that is Jafar Javed, the bench says, however, would be different if the said rules per se are found to be violated of Article 16 of the Constitution of India. Nobody has any fundamental right to be appointed in terms of Article 16. It's nobody's case, it's trite law. It merely provides a right to be considered. A procedure evolved for laying down the mode and manner for consideration of such right can be interfered with only when it is arbitrary, discriminatory, or wholly unfair. We are putting it both on the ground that it is arbitrary in as much as it violates the dicta laid down by the apex court in multiple cases, and on the ground that while you come to this of the many alternatives, you do not examine the other alternatives. You only say this one judgment. That itself, the lordships often say, what is arbitrariness? When you consider only one set of facts. You do not consider all relevant factors. Let us for a minute assume that that judgment that they are relying upon, namely Baloji Badawat, was binding. they would also have to see the other judgments. After Balaji Balawat, because they said that Balaji Balawat is not good law.
In a specific, it is not overruled.
No,
And
it's
it
not
is not
specific.
even considered in Deependra Yadav.
No, unfortunately, no.
It is not considered.
Not.
Yes.
My lords, then in para 23, the very same bench deals with Chattar Singh versus State of Rajasthan. My lords, the reason why I am showing your lordships Chattar Singh is, Chattar Singh laid down the formula that while you are conducting tired assessment, the purpose is to filter. If your end product is as heavy as your filtration product, then the very purpose of filtration does not affect. That is what they say. I'm going to show your lordships. When they say they are doing 1:50, they don't stop at 1:50. The number of people who come in at the end are much more than the 1:50, marking the 1:50 ratio.
We'll continue after the break. We'll continue after the break.
Yes.
My lords, my lord lordship had directed us to hand over the
Numbers.
list of 200 cases of limitation power. Obliged, my lord.
Item numbers 85 to 91, my lord, they are connected to other matters. I'm giving a list, they may be posted along with these.
Get these matters listed in the on Monday. Yes, madam.
85 to 91 are connected to other matters, my lord. I've given the numbers, they may be posted together, my lord.
85 to 91 final hearing.
Final hearing. Those are insurance appeals, our appeals are also to be posted along with
85 to
them.
91 as spread list with MSCMS such and such.
Much obliged.
You mention after the break.